Mr. Chen, let me come to you first. Now, last month, the World Intellectual Property Organization reviewed that China filed more than 43,000 applications under its Patent Cooperation Treaty in 2016. That's up some 44% compared with the year before. China now ranks third after the United States and Japan in this regard. What do you think are the reasons behind this achievement? Do the figures signify that China has changed into an innovator rather than a copier?
I think this is certainly a very remarkable result for China to achieve in such a short period of time. But it's going to be a long way to become an innovation-driven economy. But certainly this is something really that people should be encouraged to see the development in the history of the country. Two things I want to mention. First is that the Chinese government's role in promoting and raising the awareness of intellectual property protection has been remarkable. And in the meantime, the awareness of the public in the last 1 or 2 decades has been raised to a very high standard. So the companies, entrepreneurs are now very aware that we are competing on international level instead of competing national level. Mm-hmm. So it's very important for the country and for the economy to survive and to survive well in today's competitive economy environment.
Mr. Schwimmer, now China has long been seen as a land of copycats, and a lot of people still talk about that. According to your experience and your daily practice, how do you view China's performance in this regard? Do you think China has improved in what regard, and where China is still lagging behind?
I think it is incredibly gratifying to see what is going on with China. I have been an intellectual property lawyer for 30 years, and candidly, when I started out in this, China was a little bit of this unknown territory. It was a black box with regards to obtaining rights and protecting rights. And now it has really come into its own as a member of the international intellectual property community.
Wow, it's really nice to hear that. Now, Mr. Chen, over the years, as we have heard, Chinese government has placed great efforts into protecting intellectual property. For instance, China has made amendments to its IP laws and has set up actually a few national IP courts to handle these cases. Have you dealt with these causes? Could you share with us how these courts function and how these government policies, legal instruments are helping in the effort of IP protection?
Well, on the legislation front, the laws governing intellectual property have been constantly updated, revised to make it up to date, to make the laws being able to deal with the needs of the real market and what the society needs. And in the meantime, in the cities like Beijing and Shanghai and Guangzhou, where intellectual property cases are mostly concentrated in these big cities, specialized intellectual property courts have been set up. And from my personal experience in dealing with these cases, I am very happy to say these courts are very, very professional, very good, up to international standard. The judges are well educated, well experienced. Many of them have been educated in Western countries, so they really have the knowledge and ability to deal with the most complicated intellectual property cases, including patent cases, technical issues, whatever. So I'm very impressed, and I'm very happy to say that I'm lucky that I'm practicing at this time when the intellectual property rights are so much promoted and people are paying so much attention to this important right in the market economy.
Mr. Schwimmer, now it's reported that China is increasingly being selected as a key venue for patent litigation between non-Chinese companies. What is your observation on that, and what do you think could be the reasons behind that?
Well, I think the simplest reason is the importance of China as a market, that if patent infringement takes place there, then the patent owner has to enforce their rights there, if at all possible. I want to repeat what your other speaker said, which is that we're very gratified by the specialized intellectual property courts. There is not something comparable in the United States. It sends exactly the right signal of giving confidence to non-Chinese companies that their rights will be recognized and handled competently in China. I may not agree with every decision that these specialized courts render, but I don't agree with every decision that an American court comes out with.
Well, let's talk a little bit about some new challenges we're faced with nowadays, as we are all looking into that thing in our hands that's called mobile devices. It is reported that IP infringement on these on these digital devices are rampant these days. What are the new challenges that we're faced with, and are we equipped enough to deal with these challenges for the near future, Mr. Chen?
I think the basic principles in dealing with these infringements, whether it's online or offline, should be the same. I mean, the standard or the criteria in dealing with these infringements should be the same. I think this is just a different form of transmission of knowledge, data, or whatever kind of things that people are seeking to enjoy or whatever. On the first part, I think it's very important to raise the awareness of the public. If you go to a bookstore and you steal a book, so it's stealing. But if you go to a digital world, you go to the internet, you steal something, it's still stealing. So I think it's very important to raise the public's awareness that whatever you steal on the internet or whatever devices you steal, it's IP, it's the right of another party that you should respect, and you should not have done so. Mm-hmm. So I think awareness raising is the key in this digital or increasingly internet-connected world.
Mr. Schwimmer, what is your take on this? How significant is this a situation, a problem in the United States, and where do you see we must put more efforts?
So the problem is pretty complex, and I won't be able to answer your question in just a minute or so. First, we've seen a lot of technologies that the point of them is to allow us to copy information and to distribute it easily. Photocopiers, software, MP3s, now our smartphones. And each of these developments present challenges because lawful content can be copied quickly and cheaply, and it can be done unlawfully. That's a problem. The one thing that's really different now with the internet is that there is this problem of jurisdiction. We think in terms of nations, we think in terms of national laws, we think in terms of imports and borders. What we might see is thinking about the internet, or the internet will make us think about law differently. In domain names, we have a form of arbitration, the UDRP, that is not country-based.
Yes.
So I think if we start to think in supranational ways,
well,
we may be able to control this.
We have to leave it there. I'm sorry we have to interrupt, but many thanks to the two gentlemen, Mr. Chen Xuemin, partner at the Zhongzi Law Office in Beijing, and Martin Schwimmer from Washington, D.C., partner at Leason, Ellis. Thank you very much.